respect to our opinion, if we rule in your favor, you also want us to say something about the Sixth Amendment, or to avoid saying anything problematic about the Sixth Amendment, correct? What do you suggest?
We think that the cleanest way to resolve this case when it comes to constitutional avoidance is to recognize that constitutional avoidance only comes into play where, after exhausting all the ordinary tools of construction, the court is left with competing interpretations that are plausible, and one would avoid constitutional concerns. Here, we don't think that there are competing plausible constructions. We think that Congress's intent is unambiguous. We also don't think that there's a construction that would avoid constitutional concerns, because calling restitution a civil penalty would raise
You might be referring to the Seventh Amendment.
Yep.
My question was about your footnote about the Sixth Amendment.
Right. So we don't think that the court would only need to address the Sixth Amendment if there were a legitimate claim to be made for constitutional avoidance. And we simply think that there's no legitimate claim here because there are constitutional concerns on either side. Of course, even if the court agrees with us that restitution is criminal punishment, we have alternative arguments for why restitution wouldn't implicate this court's decision in Apprendi, which we would continue to make.
Right. That's what I was getting at.